This April, the Parliament passed the Criminal Procedure Identification Bill 2022. The Act authorizes taking measurements and preserving records of convicts and other persons for the purposes of identification and investigation in criminal matters. These measurements would include fingerprints, handprints, footprint impressions, other than photographs, iris and retina scans, and other physical and biological samples. While the bill's objective was to improve investigation in criminal cases, it ends up violating the privacy of the person whose information is being collected. And there isn't a limitation as to how this information can be used, and it makes absolutely no distinction on the severity of the offense or even whether the person in question has been declared guilty or not. Moreover, this bill can end up hurting communities and citizens who are socially and economically weaker, especially because legal recourse is often not a viable option for them. Take for instance the Vimukta communities or the Denotified Tribes, who even after the removal of the Criminal Tribes Act continue to be treated like habitual offenders. We spoke with Nikita Sonavane, co-founder of Criminal Justice and Police Accountability Project, on how the existing system already impacts denotified tribes and Vimukta communities who have consistently been labelled as habitual offenders and born criminals for generations.
The criminal legal system as a whole, whether it's the police or the prison system or the judicial system, and of course the laws that they exist themselves, are designed to perpetuate violence and oppression against marginalized communities, primarily with the Vimukta communities or these communities that are known as the denotified tribes that were once considered criminalized under the Criminal Tribes Act by the British and considered to be criminals by birth. A lot of these communities, particularly post-independence after 1952, after the Criminal Tribes Act being repealed, have been treated as habitual offenders, which is just this really vague category that there exists no definition for in law. There are registers that are maintained in police stations of these so-called habitual offenders. Their demographic details are noted down, details of their friends, families, who they interact with, fingerprints, everything is stored away in these registers in police stations. And then of course, people are routinely subjected to surveillance, so much so that there are communities in Madhya Pradesh who are too scared to leave their village because if they know that they go to the market area, they will be arrested by the police. So there are several communities like that, whether there are Pardis, Kanjars. You see that the entire system has been designed to really perpetuate this narrative of criminality and to constantly treat them through the lens of being criminals, right? There are offenses in criminal law that do not require any kind of mandatory arrest, but you will see two people are found playing cards on the street and the police will charge them under the Gambling Act, and then they will end up being incarcerated. And of course, to be able to then afford legal representation, by legal representation I mean good quality legal representation, or to even be able to challenge your criminalization in some ways, people don't have the means for that, right?
With examples from my work at CPAP, could you help us understand how being a part of the system impacts the communities?
One of the first cases that we worked on was this case of this 20-year-old man from the Gond community, which is an Adivasi community, who was arrested for stealing temple bells. So, there were several police stations that filed FIR against him, saying that, this is a person who's some serial temple bell thief. He's been going around stealing all kinds of temple bells in the city of Bhopal. And he wound up spending 7 months in jail, and there were about 7 FIRs that he was charged with, and the bail amount came up to about 2 lakh rupees. And we're talking about a person who does not have any assets, of course, does not have any kind of disposable income. Somehow he managed to, get help from people and furnish those sureties, and he was released on bail. And less than 48 hours after he was released on bail, he was arrested for another matter. There are people who have incurred huge financial debts in order to be able to even sustain their engagement with the system. And I mean, there are families where on an average you will see that one family is dealing with at least 4 or 5 criminal matters. Like, once you have entered the system, even if a couple of years later, you go through that sort of rigmarole of going to court, going through a criminal trial, and you are subsequently acquitted, which is what happens in most of these cases, because the police doesn't have adequate evidence, and there is an entire system that has been designed to make sure that that narrative is entrenched and sustained, right? You hear the last names Pardi, you hear the last names Kanjar, nobody will give you a job because tum to chori ka kaam karte ho, tum crime commit karte ho, so nobody will give you a job. It's difficult to get houses on rent, and so it has that kind of impact on every aspect of your life.
When you're fighting these cases as lawyers, what are the challenges that you face?
In these cases, what is known as, the cardinal principle of criminal law, which is something that they teach us as law students, is that innocent until proven guilty. It's a principle that's been turned on its head. A major challenge for us at that point is, of course, to be able to respond to those individual cases, because that's important, but also to constantly draw attention to the fact that these are not individual cases where this is happening. These cases are by no means exceptions, but they are in fact the norm, right? To give you an example, we recently did this study on the Excise Act, right? And it's a law that regulates alcohol prohibition in sale, manufacture, etc., just like regulating the whole business of alcohol in the country. And each state has its own excise law, and Madhya Pradesh Excise Act is one of those laws, which is very commonly used in the state. It's all like 1/6 of all the arrests under Madhya Pradesh happen under the Excise Act. Most offences under the Excise Act, actually all, are punishable by a maximum of 5 years. And as I was mentioning earlier, if it's an offence that is punishable by less than 7 years, arrest is not mandatory. But when we saw these FIRs, we saw that, of course, people were being arrested, but what were they being arrested for? It was primarily people from Adivasi communities that make mahua, and it's mahua, something that people traditionally make and consume, being arrested for allegedly selling mahua, and really like ridiculously small quantities of a maximum of 10 liters, right? In one particular case, which is in the city of Jabalpur in Madhya Pradesh, there's one police station which has predominantly arrested women from the Kuchbandiya community, which is also a Vimukta community, so much so that you will see that individual women are at this point fighting like 20 to 25 plus cases under the Excise Act. At a time when the courts were saying, okay, we need to decongest prisons, and because Indian prisons are overcrowded, people were actually being incarcerated for selling mahua that is, that communities brew traditionally, right? And people were being incarcerated for not wearing masks. Essential service workers were at the receiving end of violence. And who are these people? These are all people, from SC, ST, OBC, Vimukta communities, Muslim communities.
Now, when we talk about reforming the situation, what are the changes that you envision?
One thing that is something that we've also been trying to do is build in these systems of checks and balances, right? To be able to practice accountability when there are these cases of abuse of powers, when there are instances of violence against people from the community by the police. So much of it operates on the basis of discretionary powers across the board. There are several other cases where we want to be able to push back, whether it's through the courts, whether it's through human rights commissions, and not just push back in individual cases, but also be able to, utilizing our research work, really draw attention to how some of these laws in their essence, in their ethos, are used to criminalize the lives and livelihoods of many communities, right? I mean, this is a design problem. This is not an implementation problem. So far, and for so long, we have framed the discourse around saying laws are being implemented badly, police is abusing powers, while we understand and we see value in seeing that, well, there is some sort of reform and some sort of agenda of reform that one has to invest in. That reform has to be rights driven, and that reform has to be one that is also really challenging the power that the system holds on a day-to-day basis, right? But the reform also can't be a self-serving exercise, and our struggle against the system can't be restricted to reform alone. It's important to even engage with questions of reform, even engage with questions of making the system better, with a constant focus and understanding of the fact that ultimately what is going to serve the purpose of justice is if we are able to look beyond this system.